All right. This is chapter 12, which focuses on sentencing. So, basic framework of sentencing is that judges decide the appropriate punishment. They're supposed to be tailoring the punishment to fit the crime and the offender. So, by offender, we mean examining criminal history and the seriousness of the offense. Goals of sentencing are sentencing guidelines are used here. They set limits and limit judicial discretion. We've talked some about sentencing disparities and the push to reduce those disparities by limiting judges' options. So the next couple of slides deal a little bit with why we're going to punish, because that is the goal of sentencing, is to punish. Retributive justice is kind of looking at you deserve the punishment because you're responsible for your actions. Sometimes this is called just desserts. And the thought is that society has a moral obligation to punish people who don't meet the standards, and that punishment kind of is inherently right. And it's kind of based on this social contract that we all agreed to live by the rules of society, and when you break the law, you're giving yourself an unfair advantage. And so when society punishes you in return, it's kind of restoring the balance. There are more utilitarian justifications for punishment, and those more look retribution looks backwards. It looks at the offender and what they did to come to this point. But more utilitarian justifications look forward. So not only are we going to impose the punishment, but hopefully we can convince others to not engage in the same kind of behavior. So this is kind of like the idea of maybe crime prevention, and that we punish to promote good in our society and to reduce harm. So our utilitarian punishments, the first one is deterrence. So deterrence is the idea that defendants essentially engage in a cost-benefit analysis and then decide that the crime benefits them more than the possible costs. And there are two different types of deterrence. There's specific deterrence, that this individual who engaged in the bad act has been convicted and they don't want further punishment. So if somebody got 7 days for drunk driving and then they stop driving or they stop drinking, that's specific deterrence at work. Now, if their spouse or friends heard about what happened and they also stopped drinking, that would be general deterrence. This idea that we can learn consequences of our actions from others and avoid making the same mistakes. Another utilitarian punishment theory is incapacitation, and this is where we isolate dangerous persons in jails, prisons, or possibly mental institutions. And we can engage in either collective incapacitation, where we incapacitate everyone who is guilty of a crime, or we can engage in selective incapacitation. Here, the goal is to only incapacitate those who are dangerous, more violent. All right, our next utilitarian theory of punishment is rehabilitation. And this is the idea that we can impose restrictions that will result in the defendant being reformed or changed. We can kind of remove criminal tendencies by providing treatment, by providing mandatory drug testing, things like that. All of those are geared at rehabilitation. And then lastly, so the first three, deterrence, incapacitation, and rehabilitation, all look at punishing the offender, but restorative justice looks at kind of repairing the relationship between the community, the victim, and the offender. Everyone who was involved in the harm gets to participate in a restorative justice program, and maybe we get restitution or community service or something out of it that makes the community whole again. Okay. Um, so those are the reasons why we punish, but the next question is how much should we punish offenders for their crimes? And under the retributive approach, the just desserts, offenders deserve formal punishment, and we should punish on proportionality. So the punishment should fit the crime and be equivalent to the harm they caused. Note that that retribution relies on equivalent punishments, not identical. So we don't, we don't burn an arsonist. We don't burglar a burglarist. It's not identical. It's geared at harm, not matching their harm, but reducing the harm. Under utilitarian approaches, the amount of punishment needed is to prevent the offender from reoffending. So it should not necessarily be harsh. It should be sufficient to stop more offending. So under deterrence, we kind of looked at swift and certain punishments. It's very harsh punishments actually tend to have the opposite effect. The offender is less likely to respond to the deterrence. Meanwhile, where if the punishment is swift and certain, it's much more effective. For incapacitation, we should punish you equivalent to the risk, so we should remove you from society for the amount of time that covers the amount of risk you caused. And we should do this for those who are crime prone and not. Under rehabilitation, it's very individualized, and the judge should look at what can we do to reform this particular offender. All right, so those are kind of who and why we punish. There's a lot of theory there, so if any of it's confusing, definitely reach out with questions. The next chunk deals with the judge's options at sentencing. So judges' discretion kind of declines with the seriousness of the offense. The sentencing guidelines kick in. In 31 states, maybe less than that now, the death penalty can be used, but it's very rarely applied. Death penalty is used under guided discretion statutes, which essentially means that at least one aggravating factor needs to exist for a defendant to be sentenced to death. It is performed under a bifurcated trial, so the first trial determines guilt or not, and the second trial determines death penalty or not. And offenders who are sentenced to death are guaranteed automatic appellate review of their case. There are a lot of constitutional issues surrounding the death penalty. It's very heavily litigated, detailing what constitutes cruel and unusual punishment. And when it's acceptable. We've seen a shift in how we execute because of cruel and unusual punishments, as well as who we execute it. We have reduced certain groups of people from the pool of eligible offenders, like juveniles, those with an intellectual disability, for instance. So, judge can use death penalty if it's available in their state. Judge can also sentence to incarceration. Incarceration includes jail. Jail is usually for misdemeanors, the more serious misdemeanors, the ones that are getting 6 months or more. Prison is for those who receive a sentence of 1 year or more, and federal prison is reserved for those who have been convicted in a federal district court. Incarceration, again, mandatory minimum sentences exist. There are certain crimes where the judge has to impose a minimum sentence. This is kind of to be tough on crime. When I practiced in Ohio, OVIs operating under the influence had a mandatory minimum of 2 days for the first offense. And it continued to jump up the more times you offended until you lost your license. And the judge did not have a choice. No, they can still go up, but they have to meet the minimum. Then there is indeterminate sentencing. Here, there's a range of sentences, and the judge will say the minimum sentence is for this offender is 5 years, but the maximum is 10. So they don't set an exact date, but they set the minimum and the maximum. Handful of states, judges only set the maximum. The statute sets the minimum. Indeterminate sentencing, the sentence is more fixed. The judge will sentence for 85 months, and then the prisoner would have the ability to be released early based on leading good behavior. Sentencing guidelines are available, but they are suggested, but they do have the outcome of limiting a judge's discretion, because if the judge does deviate, they are supposed to articulate the reason for why they have went below or above. All right. Now, so judges have those options for sentences, but we have seen an explosion in people who are incarcerated, and so we have seen some movement towards limiting incarceration due to prison overcrowding. We have seen in California sentences after October 11th, there were transfers to parole and reducing those who should be in prison. Now, another option for the judge is to sentence to probation. This is the primary alternative to incarceration. So those who get probation are those who are not likely to reoffend, those who need treatment, or those who have engaged in a less serious crime. Under probation, there's usually a list of conditions and parameters that the judge has a lot of discretion over what type of parameters that they impose. And if the probationer violates their probation, they can be arrested for the new crime, but they also will face a probation violation hearing. And at that probation violation hearing, the judge might modify their conditions or sentence them to finish their probation in jail or prison. Judges also have intermediate sanctions at their disposal. This is when they decide not to sentence to jail or prison. They might do house arrest with or without electronic monitoring. So the offender, this is usually for non-violent offenders, they would have to stay home unless they're going to the grocery store and meeting their probation officer. Judges can impose fines. They can also do shock incarceration. So the offender would get 3 months in prison and then the rest on probation, with the goal of shocking them into realizing the consequences of their behavior. And there are boot camps out there for primarily geared at youth or first-time offenders. Some of the research on boot camps shows that they tend not to have lasting effectiveness. Now, with incarceration rates and mass incarceration and overcrowding, a thought is that we might see more intermediate sanctions being used, particularly for like non-violent offenders or those drug offenders, but that's still unclear. So how do judges decide kind of within the parameters of the guideline? Judges tend to look at some offender characteristics. Are you a repeat offender? Do you have a prior criminal record? What type of crime did you commit? They also will look at victim characteristics. Who is the victim? What do they look like? What was the harm? There is some strong evidence that shows that black offenders and black victims do not receive the same amount of justice as white offenders and white victims do. And your book details that pretty clearly. Now, there is something called the jury tax or the trial tax, which means that those defendants who push forward, who are likely to receive a harsher punishment than they would have gotten if they had taken a plea deal, and they're going to usually spend more time in prison or have a longer sentence. All right, covered a lot pretty quickly. Let me know if you have any questions.